Collins.
I move that the Policing Storage of Youth Identifying Particulars Amendment Bill be now read a second time. I would like to take the opportunity to thank the Labour Act United Future Progressive parties for the support for this legislation. I'm going to deal with a couple of issues that have been raised in the previous debate. The first was the issue of a conspiracy. This was raised by the member for the Murray Party. I have to say I'm particularly concerned by that one because it sounded as though the Murray Party hadn't been given a copy of the bill until last evening. Actually, they had a copy of the bill 10 days ago, as one would expect from a confidence and supply partner, so I have to say I'm a bit disappointed at that. And anyone who has any dealings with me, Mr Speaker, would understand that I'm not someone who indulges in conspiracies. I do things pretty straightforward. So I'd have to say I'm very disappointed in that sort of implication. There was also an issue around that was raised about whether or not this should go to a select committee, and that was raised by the Green Party member, and I acknowledge that that was his concern. This matter did actually go to a select committee over 2 years, well actually 2008, over 3 years ago, when it was a part of a very long process, as the Honourable Annie King has related, a 2-year process to get this, what was then that bill, right. And yet there were still unintended consequences. And I don't cast any aspersions on people because basically when we have long processes like this, when we have very complicated pieces of legislation with multiple rights that they're trying to connect through to other acts that have been around for a long time, it's very important to understand that occasionally something's not going to work right. And the reason, Mr Keith Locke has asked for some information as to basically, I think essentially, well, what went wrong, and I think I'm happy enough to provide that information to the House. Well, the 1958 Act essentially said that if a person has had these particulars, these are fingerprints and photographs taken, and they have been acquitted, so in other words, found not guilty, then those must be destroyed. The new Act, the 2008 Act, that actually turned it right around and said that police could not retain the particulars, the photographs or the fingerprints, unless the person had been convicted. And there are a couple of other exceptions, such as diversion and Section 102. But mostly, basically, it said it had to be convicted. Now, where this became a problem for youth, and the youth issue, is that in the youth court, which has been set up, as has been rightly noted, in many ways to protect youth from themselves, actually, to try and deal with their offending, not to hide from it, but to deal with it in a sensible way at a time when an intervention can make the most difference to their lives and also to the lives of potential victims. So that came, essentially most of the interventions, as they're mostly known as in the youth court, are not considered to be convictions, even though the youth has, in many cases, said, yes, I did the crime, yes, this is what I expect to happen. There has been a family group conference, there's been some interventions made. So the only convictions really that would be covered by this would be ones where the youth has been sent by the youth court through to the district court for sentencing. And so these would be very serious offences, such as rape, such as murder, such as manslaughter, very serious offences. And so, in other words, all of these other what we loosely call convictions and normally would not be counted as convictions. So things like burglaries. And I don't think it's in the best interests of young people who have offended to ignore the fact that they have committed burglaries, to ignore the fact that they're clearly in need of some pretty serious intervention to save them from a life of crime by saying it's all a conspiracy and the police are being mean. Well, the police aren't being mean, they're actually trying to save these young people from themselves and in many cases from a lifetime of crime. Because one of the things that we know, Mr Speaker, is the younger that somebody comes into the justice system, particularly into the prison system, an 18-year-old for instance, the more likely they are to stay there for most of their lives. And that is something we're trying to avoid. And I think that all parties in this House agree with the fact that we try to deal with these young offenders, these 14, 15-year-olds in many cases, who can sometimes cause quite a lot of harm, cause victims to feel re-victimised if these matters are not dealt with, and can actually ruin their lives. I don't think it's being smart in terms of legislation to ignore that situation and to say it's all the police being mean and we want to go around and help our young people against the police. The police are not there just to be mean to young people, they're there to actually try and prevent crime and to hold offenders to account. We do not help young people by not holding them to account when they create victims, when they in fact offend against the law. So what I will say to the rest of the House who are supporting this is that your support of this bill will help police do their job better in just the same way as was intended in 1958 and actually the same way as you intended in this House in 2008. This House did not intend to change the law in relation to the retaining of photographs and fingerprints of young people who have been dealt with and have actually committed a crime and have been dealt with in the youth court. This House did not intend that to happen. It was an inadvertent drafting error, and the process had gone on for over 2 years. So to suddenly talk today about how really we need longer processes, well, there's an example of a long process that didn't quite work quite the way it was intended, although most of it in that Act did. And I think it's a good Act, and we were very pleased to be able to support it from this side of the House. So, Mr. Speaker, in essence, can I say this bill is all about restoring what everybody else would have thought was the status quo, and to helping the police in their constant fight to prevent crime and to hold offenders to account and to protect the rights of victims. I commend this bill to the House.
The question is that the motion be agreed to. The Honour